So, Professor Pasquale Annicchino from the European Union Institute.
European University Institute.
Thank you.
So, thank you very much. I'm very happy to be here. Thank you very much, Joseph, for inviting me, and thank you very much for all the people that have been involved in the organization of this event. My presentation would have a slightly less theoretical focus, let's put it this way, even though I'm supposed to be also somebody who does legal theory and sociology of law, but it's just because when Joseph invited me, I was working on this paper that is due to appear in the June issue of European Public Law. It is a UK-based journal, and the topic of my article actually is protection of religious freedom and LGBT rights in the public sphere, and what is the impact of that on the debate on religion before European courts. I will focus in my presentation only on the first part, and therefore how migration and asylum law are changing the debate on religious freedom in the European Union. Now, I'm called to a very difficult also task because of the person that have presented before me and the person that will present after me. As you will probably hear in a few minutes by Brett, sorry Brett for anticipating that, debates and conversation on the role of religion in public life have been going on for centuries, and new models constantly emerge and are proposed in order to reshape the boundaries of law, religion and politics. This is even more true today. Debates over the role of religion in public life are, of course, constantly a topic of conversation among academics and in the media. To this extent, and even more today, Europe and its degree of secularization, or better say, marginality of religion in public life, are perceived as an exception in a world where religion is becoming one of the fundamental factors in shaping public debate and within the political arena. And we have heard that already from some intervention and some presentation today. As a European, I would largely subscribe to that statement. This is evident for me from both what I would call generational anecdotal evidence and also from researches coming from sociologists of religion. This is also well reflected today in reflections coming from religious leaders and court decisions. For instance, in a forthcoming book, Catholic Robert Sarah, the title of the book is Dieu or Rien, God or Nothing, explicitly argues along the line of all those who have argued that Europe has forgotten its Christian roots and therefore has basically trashed religion out of the public sphere. Decisions from national courts and from European Court of Human Rights are also a constant reminder of the not very central role that religion plays in the life of many ordinary Europeans. And I mean, this is evident if you look also at decisions coming nowadays from national courts, the fact that the judiciary always try to understand religion as something private and not as something that belongs to the public. The rise of ISIS and other fundamentalist groups after the so-called Arab Spring have nevertheless revamped the debate on the role of religion in public life also in Europe and even before the European Court. Even within that tragedy, we can find at least something good. I would argue that there is, in this paper and in this presentation, I would argue that there is a hidden narrative on the religion that is now emerging from court decision in Europe that has to do with the rising number of people persecuted because of their religion or belief. We are faced with a growing number of decisions from the European Court of Human Rights and the Court of Justice of the European Union. For those of you who are not familiar with the system, the European supranational system of protection of human rights has two main bodies or courts. One is the Strasbourg Court, where that scrutinizes also legislation in countries that are technically not members of the European Union, such as Turkey or Russia, or even though I don't know for how many months Russia will still be part of the Council of Europe. And the other court is the Court of Justice of the European Union, which is in Luxembourg. It is actually the official court of the European Union. Now, both courts have been called especially in the last 2 years, on deciding cases dealing with persecution because of religion or belief. Needless to stress how these decisions are particularly relevant for Christians in the Middle East. a small flock, but one with a great responsibility in the land where Christianity was born and first spread, as Pope Francis reminded us. Pope Francis asked also to do something more. He says in his letter to the Christian in the Middle East, and I'm quoting, "The tragic situation faced by our Christian brothers and sisters in Iraq, as well by the Yazidi and members of other religious and ethnic communities, demands that all religious leaders clearly speak up out to condemn these crimes, unanimously and unambiguously, and to denounce the practice of invoking religion in order to justify them." And again, this is, I think, another important point that also emerged, for instance, from the intervention from Professor Casanova before. As lawyers, when we deal with court, there are only a small sets of problems that court can resolve. And the majority of these problems we are called to face probably is the politics that is called to resolve these problems. Now, let's have a look at the actor that I want to analyze in my presentation, and is exactly the judiciary. Sometimes the decision taken by the two courts have met the standards required in very difficult and turbulent political times. Sometimes I would argue the decisions have not been satisfactory, and my claim is that European courts are to be called to take religion more seriously. In recent years, the European Court of Human Rights, so it's the Strasbourg Court, has dealt with several cases where it has been asked to decide upon asylum requests on behalf of people who claim that, if sent back to their country of origin, they would face persecution because of their religious affiliation that would violate Article 3 of the European Convention, which prohibits torture, inhuman or degrading treatment or punishment. Article 3 prescribes an absolute right which is non-derogable even in time of war or emergency. States, therefore, can never suspend or derogate from this article. In order to violate Article 3, the conduct involved must attain a certain level of severity. We have, of course, several cases, and I will refer to some of them. If you are interested, please ask me, and I will be happy to circulate the draft text with all the references that are there. Paradoxically enough, one of the leading cases where we can witness an interaction of the norms on asylum law and the provision of the Convention is the case of ZNT versus United Kingdom, in which the European Court of Human Rights was called upon to decide on whether a contracting state would violate not Article 3, but Article 9 of the Convention by refusing to grant refugee status to two female Pakistani applicants. The applicants, both Christians, claimed that if returned to Pakistan, they would be deprived of their right to freedom of religion and belief. They also argued that if returned to Pakistan, they would be obliged to conceal their adherence to Christianity due to fear of discrimination or persecution. The court reaffirmed, first of all, that member states may be held liable indirectly through placing an individual at a real risk of a violation of his rights in a country outside the jurisdiction of the court, especially in situations involving Article 3 of the Convention. However, for the court, and I'm quoting here, where an individual claims that on return to his own country he would be impeded in his religious worship in a manner which fell short of those prescribed levels, the court considers that very limited assistance, if any, can be derived from Article 9 itself. Otherwise, it would be imposing an obligation on contracting states to act as an indirect guarantor of freedom of worship on the rest of the world. Now, you can see this is an application filed under Article 9 to the court because of religion persecution, and the court says, we cannot help you because we are not going to apply Article 9 extraterritorially. So this application would have been successful if probably filed under Article 3, as we can see from other applications that have been filed. But under Article 9, where persecution is involved, the court says it's not our business. Now, other claims have been more successful, as I said, under Article 3 of the Convention. So, for instance, in ZNS versus Turkey, the court found that the applicant, because of his conversion to Christianity, would risk to be subject to persecution in Iran. Recently, in the case of NK versus France, the court dealt with the asylum request again of Pakistani national to France on the basis of persecution because of his conversion to the Ahmadiyya religion. The applicant claimed that he was detained, tortured for several days before he was able to escape and forced to leave Pakistan because of his issuing of an arrest warrant by Pakistani public authorities. In these cases were filed under Article 3 of the Convention, and the court found a violation of Article 3. And the court also added something more. The court, and this is a first step of many decisions that are relevant for how we understand religion in public life. The court says that in order not to be persecuted on religious ground, one religion must be practiced public, and there must be evidence that the followers of a given religion are persecuted. In this first set of decisions, the European Court of Human Rights is beginning to associate religion with something that is done publicly, and not something that you can, you can do it in a hidden way, and then you can rely on that for not being persecuting. Now, with this application, therefore, the two applicants had been able to show that they would risk persecution if they're sent to Pakistan. And the same rationale can be found in the decision, for instance, of ME versus France, where the applicant was not a member of the Ahmadiyya religion or a Muslim minority, but he was a member of the Christian Coptic Church from Egypt. And after his arrival in France, and after a complicated relation with French authorities, he requested asylum because of his removal to Egypt would have exposed him to persecution, entailing a violation of Article 3 of the Convention. So under Article 3 of the Convention, we find basically nowadays application from religious minorities coming for all kind of stream of confession and religious groups. Now, how does the court assess if there is a violation or not? First of all, what the court is called to assess is the claim of sincerity, as we have been discussing this. I mean, we have had also cases where people, because they wanted to have asylum, they would claim they were converted, but the court found that actually the conversion was not sincere, and therefore asylum was refused. And this has been the same. There has been a recent decision a couple of weeks ago by the Court of Justice of the European Union, where you would have people that ask for asylum to in European states because they claim that they are gay or homosexual, and then the problem is, how do you assess if somebody is really gay or homosexual and run the risk of being persecuted if sent back to his home country? Now, what has made the difference, especially before Strasbourg judges, has been the description of the situation in the country of origin. And the court basically has proceeded on the basis of international reports, and international reports such as the reports compiled every year by the US Commission on International Religious Freedom, reports produced by international organizations such as Amnesty International, and so on. Now, there can be also problems with those reports, because those reports constitute the evidence on those facts, and sometimes those reports are contradictory. And therefore, probably within the global law religious movement, there is probably a need to have some report that can be trusted and used by court. Because, for instance, I remember a case where a judge from the European Court of Human Rights said they would never use reports coming from the US Commission on International Religious Freedom because the Commission is a United States agency and does the interest only of the United States. And you now constantly find also critiques of those reports, even by judges. Now, an interesting case to this respect is the case of FH versus Sweden. In this case, an Iraqi national applied for asylum in Sweden, relying on other grounds on Article 3 of the Convention. The court, proceeding on the basis of international reports, although recognizing the problematic situation in Iraq, found that Christians were still able to congregate, and that violence targeting Christians was organized not by non-state groups and condemned by states and by Islamic groups. So here we have the judges that are saying, okay, maybe that there is something going on, but the violence down there is not coming from the Iraqi state, but is coming from other groups, and therefore we cannot grant asylum to those Christians coming from Iraq. And here we have a very powerful dissenting opinion by two judges that are Judges Power 4, that no longer serving on the court since last year, and Judge Zupanits. And the two judges said that the fact that the violence is not non-state sanctioned is not the requisite test to proceed to fight a violation or not in this case. And their conclusion, the conclusion of the majority in this regard, is difficult to reconcile with such objective evidence as is available. And they relied, among many other reports, to show that actually Christians were persecuted in Iraq. Now, The record of the European Court of Human Rights, therefore, on the issue of the role of the notion of religion and religious freedom and religious persecution, and the fact that religion is something that you must be able to do in public, it's a little bit contradictory. You will find some cases where this has been recognized, and some other cases where, as in the case of these Christians in Iraq, this has a little bit been neglected. The interesting thing is that now we have an important decision from the Court of Justice of the European Union that can be very helpful in moving forward the protection required and the understanding for a wider notion of freedom of religion and belief. Now, the Court of Justice of the European Union has been called to interpret, especially for what matters to us, Article 9 of the 2004-83 directive that defines acts of persecution within the meaning of the Geneva Convention by providing a non-exhaustive list of acts which may consider within the definition of persecution. They include acts such as physical or mental violence, legal, administrative, police, and other judicial measures which are in themselves discriminatory or are implemented in a discriminatory manner, or persecution or punishment which is disproportionate or discriminatory. In the case that is ENZ versus Germany, the two applicants were two Pakistani nationals, members of the Ahmadiyya community again, whose request for asylum had been denied by German authorities because, according to the interpretation of German authorities, the restriction placed upon them did not amount to the level of persecution. The Court of Justice was therefore called by the German court to interpret the notion of act of persecution as prescribed by the directive of 2004-83. Now, what did the court say, the European Court of Justice say in that case? Two quotes. The first quote is this: "For the purpose of determining specifically which acts may be regarded as constituting persecution, it is unnecessary to distinguish acts that interfere within the core areas, forum internum, on the basic right to freedom of religion, which do not include religious activity in public, forum externum, from acts which do not affect those purported core areas." Now, the German government basically said, we can grant persecution if we are able to show that there is a violation in core areas of freedom of religion or belief. And what are those core areas? Core areas are the fact that you are persecuted just because you claim that you belong to a religious minorities. We are not going to grant asylum if it is claimed that persecution belongs to non-core areas, and non-core areas are areas that belong to the forum externum. So, you know, having the possibility of having a prayer and all the rites that are part of a given religious group. And basically the court said that such distinction is incompatible with the broad definition of religion given by Article 10 of the directive, which encompasses all its constituent components, be they public or private, collective or individual. Acts which may constitute a severe violation within the meaning of Article 9 of the directive include serious acts which interfere with the applicant's freedom not only to practice his faith in private circles, but also to live that faith publicly. This is the quote from the Court of Justice of the European Union, that coming from a European court is a quite strong statement as far as the understanding of religion in public life is concerned. You basically here you have one of the most, I would say, the most important European court basically telling to national government that religion is something that is deeply public and not only private. And again, therefore, and the court underlines how Article 2 of the directive must be interpreted as meaning that the applicant's fear of being persecuted is well-founded if, in the light of the applicant's personal circumstances, the competent authorities consider that it may be reasonably thought that upon his return to his country of origin, he will engage in religious practice which will expose him to a real risk of persecution. In assessing an application for refugee status on an individual basis, those authorities cannot reasonably expect the applicant to abstain from religious practice. Again, this is a very strong statement where the court says you cannot send somebody back just telling him, okay, you want to have a prayer, just gather a few friends home, you will pray home, you don't do it publicly, and you will be fine, and nobody will persecute you. No, the European Court of Justice is saying the violation of freedom of religion and belief, we should count on also those that are public, and people should not be able to abstain if they want to practice their religion in public. Now, I don't want to enter in all the details and in the many decisions that have been influenced by this national decision that have been influenced by the judgment in Y and Z against Germany. What is important to stress is that in a case that is pending now before the European Court of Human Rights, and the case is FG versus Sweden that was debated before the Grand Chamber some months ago, and the final judgment is going to be delivered, I think, in 1-2 months. The facts were basically the same, but the European Court of Human Rights reached totally different conclusions as compared to the Court of Justice of the European Union. And again, in that case, in the first instance before the panel, we have some dissenting judges from the European Court of Human Rights that relied to criticize the opinion from the Court of Strasbourg on the opinion of the Court of Justice of the European Union. And this is what the judges in Strasbourg wrote in their dissenting opinion. We consider that there is nothing under the case law of this court which holds otherwise when it comes to the European Convention of Human Rights, quoting from the Court of Justice of the European Union. The majority of the judges did not concur with this opinion and will now up to the Grand Chamber of the Court to decide if the Court of Justice of the European Union shall follow the opinion delivered by the European Court of Justice. At the heart of Europe, there is a struggle now on the understanding of the role of religion in public life. One of the two sides of the struggle is represented by many positions taken by the European Court of Human Rights that has often said that in cases dealing with persecution, you will be fine and people will be sent back if they are still able to practice their religious faith in private and congregate in private. On the other side, the Court of Justice of the European Union has taken an approach that is completely different. It says that when religion and freedom of religion are concerned, we should make sure that people are able to practice their freedom of their religion in public, and religion is something that you do in public. This European dilemma will be solved, I hope, soon by the Strasbourg Court in the decision of FG versus Sweden. My take on this is that the decision taken by the Luxembourg court is much wiser. Therefore, I take the opinion of the dissenting judges to punish power for the elements in the Strasbourg court. I'm not sure that the Strasbourg court will follow the Court of Justice of the European Union, but in the next few months we'll know. And probably my take is that if we look, there is a parallel development of cases dealing with LGBT rights and freedom of religion before the two courts. And for LGBT rights, the approach has been quite wide in interpreting the need for protection vis-à-vis persecution for LGBT movement. Therefore, probably if the Strasbourg Court follows that lines of argument and interpretation, we can make sure that probably we can better protect people that really risk their life just because of claiming their right to freedom of religion or belief. So thank you very much. And again, those of you who are interested, I'm happy to share the paper.
Thank you.
I just have a question, and I'm not sure this goes to the substance of your paper as to how the panel fits together, and I realize you're not necessarily responsible for that, but you stressed at various points that these cases help document the fact that religion has a public dimension. But it seems to me that is fundamentally different than the argument that public reason would be a barrier to relying on religious premises to shape public policy. And I'm just checking, I'd be interesting if you see more of a correlation, because on the one hand, you may just be saying there's internal forum and external forum, and of course you could have a public dimension of religion, i.e. manifestation of religion, without necessarily saying, and that entitles you to use your freedom extends to shaping public policy. So I'm just
Yeah.
questioning
No,
if there's an overlap.
I think, I mean, as I said in the beginning, this was the paper on which I was working when Joseph invited me. And I think that there is something that is key to this in the decision from the Court of Justice of the European Union that you would rarely see, even theoretically, I would say, in a decision from a European court or even in the writing of European scholars, in the sense that religion is something public and not that religion is something private. And I think epistemologically this is a big step to be taken by a court, because we can have, I mean, that decision by the court, if taken seriously, also in cases that are not dealing with religious persecution, but what does it mean, that statement in the judgment, when you are dealing with bioethical issues or any other kind of, cases that court can be called to decide? What does it mean if the Court of Justice of the European Union is called to decide a cases against a member state where somebody wants to have religion as a premise of his political position? Then you cannot step back and say, oh, no, religion is something private. But you need to be able to assess and to respond on the fact of your previous statement that religion is something public, and religion is something that you do in public, and therefore I am very much interested in seeing the development of the case law of the Luxembourg court on the premise of that decision, because we have to, contrary to the Strasbourg court, we don't have many decisions on religious freedom from the Luxembourg court. I mean, it's a very new court to be dealing with these topics. We have very few decisions, but these are decisions now based under Article 10 of the Charter of Fundamental Rights. And legally, if you compare Article 10 of the Charter with Article 9, there is one legal fundamental distinction, is that Article 10 has no second comma. So Article 10 has no limitations to the right, and therefore it's the court that is called to set out the limitation of the exercise of the right. And I mean, I very much look forward to the court to have more cases, and I think that more cases, maybe not directly through religious freedom, maybe through discrimination and so on, will come to Luxembourg and see how the court will reconcile this wide understanding of religion in public life with the traditional cases on religious freedom that we have seen before the Strasbourg court.
Just to follow up on Cole's point and another quick point. This distinction that you make between a public and a private is not the same distinction that there's another distinction between public and private, which is the state and the individual. So obviously, an individual, when he goes to into the public, should be able to express their religion, and this is what the court. The Luxembourg court is basing its decision on. That doesn't necessarily mean that religion has a place in the state as a public sphere or in the public political sphere. So that's, in that sense, it's very different from, I think, because public reasoning goes to what the state should, how the state should
So maybe
interact with religion.
I'll add a question then to this line, which it seems to me that what connects both your papers in a way is beginning to unravel and point at fissures and breakdowns in the definition of religion that by their very nature are going to undermine the way that we think about the doctrine of excluding religion as public reason in the public sphere. Because the classic debate about religion and public reasons is a debate really about citizens talking to one another. Right? How do they understand, right? Citizens talking to one another and being justifying and having justified to them the notion of why a law is or is not applicable, and what right, and what sort of state they're going to have. So I think what's very interesting in both cases is that I think your example, to some extent, shows the limits of understanding religion as dogma and tenet. Does underlie this, right, this sort of classical discussion of religion and public reason, and yours is precisely this notion of religion as private rather than performed in public, because once you think about religion as something that of course is performed in public, then the whole doctrine of public reasons takes on another coloration, because then we are in some way conceding, right, that an individual cannot come to the public sphere denuded from religion, And then why can't he discuss justifications that also have religious roots? So I think we can see this
Yeah.
connection with
No,
the topic of the panel
I-
that's really profound.
Can I just make my second point? Sorry. So again, I don't want to be provocative, even though everything I say is provocative, but yeah, no, so now it's a provocation to the European Court. So what would the European, a European court which, and perhaps it has, perhaps it's connected because the Strasbourg court is the same court that decided that the French law prohibiting women from wearing the full face veil in public is legitimate. Now, what would the Strasbourg court say, how could it say on the one hand, if it were to follow the Luxembourg court, how could it on the one hand say, if you can't express your religion in public, you're persecuted and then we can give you asylum, but on the other hand have, a decision such as the SAS decision.
Yeah.
So I think
in fact, I think that the SSS, it is the Luxembourg court that gave this wide understanding of religion in the understanding of the case law. And I wouldn't be surprised that if the case such as SAS went to the Luxembourg court through the anti-discrimination prism, would have resulted in a finding of no violation of violation of the law because of discrimination against Muslims, and therefore again, I mean, it's a constant reminder of this balancing act between what is public and private. It is not only something that has to do with Europe, basically. I mean, I have just completed a book on international religious freedom, and you see these trends everywhere, especially when religion is mixed with nationalism. I mean, what is the public role of religion? What is the private role of religion? It's a global debate nowadays, and probably what we should try to do is to have some kind of common categories to operate the kind of distinction we need to operate, and trying to find a proper balance between this notion of public and private. But I agree with you on your last comment on your. I think that SAS is wrong, but is in line with a certain understanding of the court, basically. So it's in line with. I mean, you might be surprised, but I think that SAS is completely in line with the Lautsi decision. Basically, it's completely in line with the Lautsi decision. Now, is something good or bad? I think they are both bad, frankly, because if you are a religious minority in Russia, I said that I was invited in Georgetown, and the people were all happy about Lautsi too. I said, look, if you are a religious minority in Russia, you probably you don't want to be that happy about a decision that gives to the states all possible margin to discriminate against you. And now many religious folks that were happy with Lautsi too, they are starting to, rethink their approach to the fact that you give an ample margin to the states to do whatever they want with religion, and there is no scrutiny on that. So I don't know how the European Court of Human Rights will proceed on that. My take is that we will not get away anymore with the margin of appreciation, because, I mean, there is a political problem with the court now from many important states such as Russia or the UK, and therefore basically the court would function as a Ponzio Pilato, in the sense that the court would wash, we are in Jerusalem, so the court would wash the hands and say, okay, it's up to the states, they do whatever they want.